everybody. We are so happy to be here today. Like Kyle said, I love doing these presentations. I really think of this as a public service announcement. You should take care of this. I talk to people all the time and they have so much misinformation, or they have confusing little tidbits from different places. It's a complicated area of law. Really, estate planning, it's a wide area of law. It touches state law, it touches federal law, it's elder law, it's family law. What I like to say, first of all, is that estate planning is not for people older than you, and estate planning is not for people richer than you. Estate planning really is for you. It's for people over 18 that have concerns and just have realistic expectations how that life has it's finite, right? We only live so long. Estate planning is about protecting you, your dignity, your privacy, your autonomy. It's about protecting your loved ones. What I talk to people about all the time is grandmas that are worried that their grandchildren won't see each other. They know that their children fight, and they know that what happens, unfortunately, so often when a parent dies, is that the kids start feeling funny about what happened. They separate and the grandchildren don't see each other. It's about protecting your loved ones, shielding them from unnecessary grief. I'm a lawyer. I can't protect everybody from all grief, but unnecessary grief. And then it's about protecting your wealth. Whatever it is you've worked your whole life for, protecting it for you to enjoy for your whole life, and then passing it along at the end of your life, however you choose, seamlessly. Seamless is really the name of the game here. I want to talk to you really about how people like you can set things up. And when I say people like you, I really mean it. I'm going to use an example. Josh referred some clients to us, and I'm going to tell you about them because they're really a good example of everything that we do in estate planning. I owe them a duty of confidence and confidentiality, and I'm just going to call them Jane and John Doe. And when Jane and John Doe came to the Weingartner Law Firm, I guess now it's been about 10 weeks or so, the first time we met, I asked, like I always ask, why are you here? Almost like a doctor, where does it hurt? What's going on? Everybody's different. Everybody has all kinds of different concerns. And Jane said right away, I want it to be seamless. I know I won't live forever. We're simple people. We've been married to each other our whole lives. We were high school sweethearts. We're easy. We're not complicated. The kids are great. None of the children, thank God, had a substance abuse problem, a spendthrift problem, a bad marriage, that stuff, that wasn't them. This is just sort of, vanilla, I guess you'd say. But she said to me, her brother-in-law had passed away recently, and her brother-in-law had written a will, and he named her, his sister-in-law, not his wife, as the executor of the probate. He didn't think his wife could handle the probate. So let me just say what a probate is, because another way that I'm spoken about is that I'm a probate attorney. And probate it's a court proceeding. It's a lawsuit. It's a lawsuit that's required if you die with stuff in your name. So stuff, your house is in your name. Your Wells Fargo investment account is in your name. Your personal bank accounts, they're in your name. If you die with stuff in your name, a court proceeding is required to get your stuff out of your estate to whomever that your things will go to. If you write a will, your stuff goes where your will says it goes. If you don't, the state of Florida has rules that say where your things go when you die. But it's a lawsuit. It's a court proceeding. There's expenses. It's public record, so there's privacy issues there. And everything is frozen while the court proceedings go through. She said, and this is Mrs. Doe again, she didn't want this for her family. She didn't want it for herself if her husband died first. She didn't want it for her husband if she died first. And she didn't want her kids to go through this. And she knew, as a Wells Fargo client, that there was a way to avoid a probate at the end of your death. And it's not to die with nothing. You know, how do you die without stuff in your name? It wasn't to die penniless. It was to create a revocable living trust. There are all kinds of trusts in the world, from asset protection to tax planning. A trust is defined as a contract, and that's really what it is. So a trust is just a contract, and it's a living trust because it's created while you're alive. So that's what that means. What's a living trust? And it's a revocable trust, and I'm going to go into that, which means it's a probate avoidance trust. There's all types of living trusts that you can create while you're alive, but the revocable living trust that Mrs. and Mr. John Doe did, and we're going to discuss it, does one thing. It avoids probate at the end of their lives because I retitled their stuff into the trust. So just like a lot of us here, they have a home. We deeded that home from themselves, Mr. and Mrs. Doe, to themselves, Mr. and Mrs. Doe, the trustees of the Doe Family Trust. They had a timeshare. We did the same thing with the timeshare. We recorded those documents in the county records. The only difference now is when they get their statements. We did the same thing. We helped them with their Wells Fargo account to change the name of the Wells Fargo account from Mr. and Mrs. Doe's account to the Doe Family Trust account. The only difference is when they get their statements, when they get their property tax bills, it comes to them as trustees of their trust. But nothing changed. No income tax consequences, no property tax consequences. It's like they took it out of their left pocket and they put it into their right pocket. That's how a revocable living trust is treated. It's disregarded except to avoid probate, because what the trust says is that Mr. and Mrs. Doe are the trustees of their trust for their entire lives, and they can do whatever they want. They can continue to make gifts to their grandchildren. They can continue to buy more stuff, use more stuff. Nothing changes, but eventually, inevitably, when one of them passes away, we don't know if it's going to be Jane or John. If it's Jane, John only has to be sad and mourn his wife, but his accounts aren't frozen. He can sell his house the next day if he wants to. He continues to be in control by himself. And the same thing, if John passes away first, Jane doesn't. There's no court proceedings, there's no delays, there's no freezes, nobody else is in play unless and until they need to be. What if something happens, Jane passes away, and John starts to suffer from some sort of dementia or age-related thing? Well, the documents say if one of them is incapable of managing the trust like they're supposed to for their entire lives, but we can't anticipate we don't know for sure what could happen in life. Things happen. In that case, I told you they had 2 healthy adult children that were good with money. They trusted them. They're entitled to step into place. They're authorized in the documents. That's what it says. So nothing changes for all of Jane and John's lifetimes. And at the end of their lifetimes, according to the contract that we worked on together, I wrote it based on what they told me. At the end of their lifetimes, everything goes to their 2 children equally. No need for a probate at John's death, no need for a probate at Jane's death, no legal fees, no court costs, no public record. It's all taken care of. But that's not it. You see in front of you, there's those 5 things. You need more than just a trust. I can't guarantee that at the end of Jane and John's death, at the end of Jane and John's lives, they won't have something else. And the thing that always comes to me is I ask, of course, that's my job, and I remind them, when you buy new stuff, buy it as the trustees. Continue to accumulate more wealth, but do it as the trustees of your trust. But what if Jane found out that she inherited something from a great aunt that she didn't even know about? And she gets so excited, she can't believe this now. She dies of shock. Just imagine, she dies, well, we can't get that into the trust, it's too late. So we have a will, a pour-over will, just in case. That will, so Jane and John didn't have minor children, but for those of us that have minor children, you can't put your babies into a trust. Who's gonna raise the children? You put that type of thing into a will, you still need a will.